only thing we have to fear is
in war.
fear itself.
There is no substitute for victory.
Let us never negotiate out of fear.
We stand undivided, forever united, fighting hand in hand for the liberty we've earned, for glory and honor, for our sons and daughters, ever mindful of the lessons we've learned. Let the torch of freedom burn.
Welcome to the intersection of faith and politics. This is WallBuilders Live with David Barton and Rick Green. We're picking up today where we left off yesterday with Mat Staver at the Pro-Family Legislators Conference. That's that once-a-year time we bring in state reps and senators from across the nation, give them a chance to spend the weekend together in Dallas, exchanging ideas, hearing from great speakers, learning about issues in other states, learning about great ideas that they could bring to their state. And one of our speakers this last year was Mat Staver, and he was covering this subject of parental rights and also rights of conscience, and certainly both of those areas under attack. You might recall last year Mat Staver represented the family of Justina. She was the gal that was literally kidnapped by the state government, and because of a disagreement over how her health was being handled. It was an awful case. It was something you don't want happening in your state. You want to prevent that. You want to keep parental rights in your state. And so Matt shared with state legislators from across the country how to keep that from happening in your state. And they're taking those ideas back to their state legislatures. Also talked about the rights of conscience coming under attack in our nation. We wanted to share that with you, our listeners here on WallBuilders Live. So if you missed yesterday, you can get that program on our website right now at wallbuilderslive.com. We're going to pick up where that program left off yesterday. And at the end of the day, then we'll pick up again tomorrow and get the conclusion of that. So it's a three-part series with Mat Staver at the Pro-Family Legislators Conference. Here's Matt.
This particular law is a state law, and it says a parent or legal guardian shall not be charged with abusing or neglecting a child's need for medical care if, 1, the parent or legal guardian has sought medical care for the child from a licensed medical or mental health provider. 2, the licensed medical or mental health provider has made a diagnosis. 3, the licensed medical or mental health provider has prescribed a lawful course of treatment, and 4, the parent or legal guardian is following or willing to follow the recommended course of treatment. No mandatory reporter as defined, and that's section of Massachusetts law. You'd have to put it in your other law, but this applies to the hospital, for example, or other physicians or mandatory reporters in whatever your state law says. Shall file a report of abuse or neglect under, it goes on, based solely on, anyway, that particular paragraph, you'll have it in your material, basically does not allow for a medical or mandatory reporter to just simply disagree with a diagnosis and allege that it is medical abuse. So here what you have is families, not just the Pelletiers, but others in Boston Children's Hospital. We've had situations like this in California as well, and others around the country where they're following medical advice of a licensed physician or mental health provider. And they take their child to a hospital and someone disagrees with that, and they then want you to follow this course of treatment. As bizarre as you think this might sound, and as rare as you might think it is happening all over the country, and parents are losing their children over this. We had a case in California where a child had a blood condition. These people lived in Michigan. She took her briefly to a hospital in California and temporarily lost her child. We had to counsel this woman in the hospital on how to be able to get her child out. We had a woman, a mother, her husband had moved down to Alabama to get a new job. Just as she's in the car getting ready in a few days to leave to Alabama to join her husband, her 2-year-old son gets ill, she takes him to Boston Children's Hospital. Aren't they the experts? They've got children's in their name. And she ultimately got the child taken from her, and she was detained for weeks and weeks, not being able to reunite with her husband, simply because they wanted to do a particular course of treatment that was different than the doctors who were treating or other doctors who had different diagnoses or opinions. So this is a proposed piece of legislation to prevent this from happening. Again, you'll have this presented to you by David Barton. You'll have that emailed to you. So let me move from that over to religious liberty. And with that, I want to bring up an Arizona law that got a lot of misrepresentation in the media. This law was passed by both houses, House and Senate in Arizona. And you remember Governor Jan Brewer vetoed this legislation. This legislation was completely blown out of proportion. This will also be emailed to you as well. This was a modification to the existing Religious Freedom Restoration Act. Now, it came about because of threats to religious liberty coming from two different areas: abortion via Obamacare, as well as the situation in California, where now even churches are required, as part of their health care coverage, to cover abortion by virtue of the state regulation. And it also came about because of what was happening with regards to the same-sex marriage issue.
This is David Barton with another moment from America's history. Since the Ten Commandments have formed the basis of civil law in the Western world for over 2,000 years, an individual is more likely to find a copy of them in a government building rather than a religious one. Yet amazingly, numerous rulings over recent years now make it unconstitutional to display the commandments in many public arenas. Consider what Founding Father John Adams said about this. He declared, "The moment the idea is admitted into society that property is not as sacred as the laws of God, anarchy and tyranny commence. If thou shalt not covet and thou shalt not steal were not commandments of heaven, they must be made inviolable precepts in every society before it can be civilized or made free." John Adams believed that no society could remain civilized if separated from the Ten Commandments.
For more information on God's hand in American history, contact WallBuilders at 1-800-8-REBUILD.
Let the torch of freedom burn.
With regards to same-sex marriage, you had the situation in New Mexico where either same-sex marriage comes into a state and or a local or state ordinance or law is passed that includes sexual orientation or even the broader term gender identity. And when those come in, what it does is elevate sexual behavior to the same level as race. Let me just pause there again. It elevates sexual behavior to the same level as race. Whenever you add to a non-discrimination policy, whether it's a local or state or federal, sexual orientation or gender identity, as part of the litany of non-discrimination on the basis of race, etc., you elevate it to the same level as race. Same-sex marriage automatically elevates it to the same level as race. So what you cannot do legally and or should not do morally with respect to race, just substitute sexual behavior or same-sex marriage or transvestitism or transsexualism or anything of that nature, and it falls in the same category. So as an example, currently under federal or state law, religious organizations, or let's say churches, have an exemption with regards to discrimination on the basis of religion. So the federal Title 7, with regards to non-discrimination in employment or public accommodation, whether it's federal, state, or local, they always have an exemption on the basis of religion. So a Baptist church can discriminate and hire Baptists. A Catholic church can discriminate and hire only Catholics. A Presbyterian church can discriminate and hire only Presbyterians. That's the only exemption that these churches or religious organizations would have from these otherwise non-discrimination policies. But a Baptist church could not say, we're only going to hire white Baptists or white Presbyterians or white Catholics. Why? Because there's no exemption with regards to race, even with regards to religion or churches. So consequently, when you put sexual behavior, either by policy or by same-sex marriage, on the same platform as race, the implications are the same. A Baptist church can say, we're going to only hire Baptists, and someone says, but I affirm the Baptist faith and message, but I'm also in a same-sex relationship. Or I'm engaged in open homosexuality. Or I want to go through a sex change surgery. Or I want to dress like a woman, or I want to dress some other way. You will not be able to say, any more than you can say, we're not going to have an African American as the receptionist, or an African American as a pastor or priest, because you are African American. Nor will you be able to say, we're going to not have someone who is openly homosexual, engaged in a same-sex relationship, or dressing of the opposite sex like this, because it falls in the same category. So when you cross that threshold, you put sexual behavior at the same protected category as race. And what you cannot do legally or should not do morally with respect to race is the same for sexual orientation. Take, for example, the Bob Jones University case. Bob Jones University, remember, lost their tax-exempt status. Why? Because they had a policy that says no interracial dating. Now, Bob Jones has since abandoned that policy. They no longer believe it's biblical, but back then they had it as their policy. There was no federal or state law that says you couldn't have a policy like that. What was the public policy that the IRS jumped on? The non-discrimination policies on the basis of race. And so they came into Bob Jones and said, that violates public policy. We're going to revoke your tax-exempt status unless you change your policy. Bob Jones wouldn't change the policy. It went to the United States Supreme Court, and the Supreme Court upheld the IRS's revocation of their tax-exempt status. To this day, Bob Jones is not tax-exempt. They are considering reapplying for tax exemption. They no longer have that policy. Or, for example, the Methodist organization in New Jersey, when civil unions came there, they had a facility on the beach that they used for weddings. And someone came and they asked, we want to have a same-sex civil commitment ceremony. They said, no, that violates our religious beliefs. And they ultimately lost property tax exemption with regards to that particular facility. Or the wedding photographer with regards to New Mexico. And that's what's mentioned in this particular preamble to this law in Arizona. In the wedding photographer case, someone came to the photographer and said, we want you to photograph a same-sex civil ceremony. And this photographer said, no, that violates my religious beliefs. But you can go down the street, you can have this other photographer, they'll do a good job, but I can't do it. Now, the photographer was ultimately then charged with a civil rights violation under the New Mexico Code because it had sexual orientation and gender identity. The photographer said this in defense, and it's a good defense. Listen, I don't discriminate against people who are Caucasian, but if they put on hoods and they start burning crosses and they participate in a KKK rally, I cannot photograph that event. That would violate my religious beliefs. But if they want to have their birthday or some other kind of special portrait or whatever, I'll photograph them. Now, she was white, but she says, I don't discriminate against someone on the basis of their ethnicity or race, but I can't photograph this event. And the court said, no, and she said, in fact, I don't discriminate on the basis of people who are homosexual. I've got clients that I've photographed, and maybe for a birthday party or a graduation, and someone there is gay or lesbian. I don't discriminate. I don't ask them. I don't resist. But if someone wants me to photograph a ceremony that celebrates sin, I can't photograph. I cannot participate into that. And the court said, no, you have to participate in that event. And if you refuse to photograph that event, then you are therefore discriminating against them on the basis of sexual orientation and gender identity.
This is David Barton with another moment from America's history. How should we respond if confronted with frustration and conflict? The proper response was given over 200 years ago in a lengthy speech when Benjamin Franklin told the delegates at the Constitutional Convention, "In this situation of this assembly, groping as it were in the dark to find political truth, how has it happened, sir, that we have not hitherto once thought of humbly applying to the Father of lights to illuminate our understanding? Have we now forgotten that powerful friend? Or do we imagine we no longer need His assistance? God governs in the affairs of men. I therefore move that henceforth prayers imploring the assistance of heaven and its blessings on our deliberations be held in this assembly every morning before we proceed to business." Benjamin Franklin knew that prayer was the proper response.
For more information on God's hand in American history, contact WallBuilders at 1-800-8-REBUILD.
Let the torch of freedom burn.
They then said that we have religious freedom in this country, but your religious freedom has to be sacrificed to live in a pluralistic society, and you have a choice. You either change your profession and you can continue with your belief, stop photography, or if you want to continue to engage in photography, you're going to have to put aside your religious conviction. So, Arizona then had a state Religious Freedom Restoration Act. How many heard the media reports as to what this was involved in? And yeah, raise your hand. How many of you saw this on the media? When we look at the actual modification of this law, you'll see that it was completely misrepresented. They already had, in other words, a Religious Freedom Restoration Act. The question was, does it apply to someone like in New Mexico? Because in New Mexico, they tried to use the state Religious Freedom Restoration Act. And they ultimately were told it doesn't apply. Why? Because it's a private person filing a complaint against another private person, notwithstanding the fact that the government is enforcing a law, but you can't have it apply if it's a private person filing a complaint. If it were the government initiating the complaint, then the Religious Freedom Restoration Act would apply, because you have the government as a plaintiff and you as the defendant. But if the person who's the plaintiff bringing the complaint is a private individual and you are the defendant and they're complaining that you violate some state law, even though the government has to get involved to enforce the state law, there's no government action. This is what they did to attempt to resolve that in Arizona. Listen, up here under exercise of religion, it talks about the bold all cap is the addition, and so they made sure that it applied to practice or observance of religion, including. So that was the only addition there. You move down here to person. And person, it says, includes, and then they struck out a religious assembly or institution. And they added this: any individual, association, partnership, corporation, church, religious assembly or institution, a state trust, foundation, or other legal entity. That's all they did there. And then let's move to the next slide. It continues to go on. There's no changes there. And then finally, this slide here under free exercise. And here's where they made the change to make sure that it applies to these kinds of situations. They struck out the word government, and they inserted state action. So it originally said, except as provided in C, government shall not substantially burden a person's exercise of religion, even if the burden results from a rule of general applicability. So this was what happened in New Mexico. They said, it's not the government doing it. It's a private person doing it. They're using a state law, and the government's enforcing it, but the person who's bringing the complaint is not the government, it's a person. So therefore, you don't have any state Religious Freedom Restoration Act. So what they did here is they amended it, and they said, except as provided in subsection C, no change there, struck out the word government, and they said, of this section, state action shall not substantially burden. Next one, they struck out government. State action may substantially burden a person's exercise of religion only if the opposing party demonstrates that the application of the burden to the person or in this case, person's exercise of religion in this particular instance is both, and it goes on. All the rest of it's standard. And then D, it says, to be clear, regardless of whether the government is a party to the proceeding, the person asserting such a claim or defense may obtain appropriate relief. That's all they did. They wanted to make sure that if a private individual brought an action against another private individual, alleging that you're violating some law, and the government has to get involved to enforce the violation of that law, then that's just the same as if the government initiated it themselves. You still have a religious freedom claim. Now, if you were to go back and replay all the clips as to what this law was doing, you would have thought that they substantially amended this law. And they didn't. The amendments are very minor. It just simply says, we're not going to have the same situation in Mexico. If a private person brings an action against another private person, and they're trying to enforce some law, and the government has to get involved to enforce that law, then it's the same as if the government initiated the action and you got state action. That's it. That's all it did. Didn't change anything else. It's not this parade of horribles that's opening up. It's not this wild Pandora's box that is going unchecked. But you would never have known that by just simply listening to the media reports. And unfortunately, Governor Jan Brewer listened to the media reports, ignored the scholarly papers and positions from professors and other constitutional lawyers on this issue, didn't really pay attention, or her advisors, to the actual language, and came out under public pressure and unfortunately vetoed this law. Now, shortly after that, a virtually identical version of this law was passed in Mississippi. Now, let me spend the remaining part of my time on this issue, because this is, I think, religious freedom, particularly with the same-sex marriage scenario that is happening, is the cultural clash of our time. You know, if you look at abortion, from 1973 until Obamacare, we had abortion in this country. We've killed 55+ million children. We've decapitated them in the same way that ISIS has decapitated its prisoners. We've brutally dismembered our children in the womb. As brutal and as horrible as that is, we've been able to drive by, unfortunately, abortion clinics without even thinking about what's happening. We haven't been coerced to participate in the actual participation of abortion until Obamacare.
Hey, this is Tim Barton with WallBuilders. And as you've had the opportunity to listen to WallBuilders Live, you've probably heard the wealth of information about our nation, about our spiritual heritage, about the religious liberties, about all the things that makes America exceptional. And you might be thinking, as incredible as this information is, I wish there was a way that I could get one of the WallBuilders guys to come to my area and share with my group, whether it be a church, whether it be a Christian school or public school or some political event or activity. If you're interested in having a WallBuilder speaker come to your area, you can get on our website at www.wallbuilders.com, and there's a tab for scheduling. And if you'll click on that tab, you'll notice there's a list of information from speakers' bios to events that are already going on, and there's a section where you can request an event to bring this information about who we are, where we came from, our religious liberties and freedoms. Go to the WallBuilders website and bring a speaker to your area.
Let the torch of freedom burn.
And Obamacare, both with the employer mandate, and that's made very popular by the Hobby Lobby case, which they dodged that bullet by only one vote, and it only applies at this point to closely held corporations. It doesn't apply yet to Little Sisters of the Poor, says that if you want to do business, you've got to participate in human genocide. So Little Sisters of the Poor are sisters that are called and believe that God has commissioned them to minister to the people that are cast to the curbs of society. These are the people that are the elderly, the sick, the infirm, the disabled, those that are kicked to the side of the curb. And that's where they minister, not only here in the United States, but also internationally. They're being told that as a consequence of their mission, you can still do it for now, but to do it, you have to participate in human genocide. Liberty University, training champions for Christ, the largest Christian university in the world, or other Christian universities. You can continue to train champions for Christ, but you have to participate in human genocide. Now, think about that for a moment. No country in history has ever forced its citizens to participate in human genocide. If you go back to the Armenian genocide, one of the first genocides, the Nazi genocide, the Rwandan genocide, the genocide that's happening in Iraq right now, the government is engaging in it, or rogue individuals or entities are engaging in it, but they are not forcing their citizenry as a whole to participate. For the first time in world history, our government is saying, as a criteria to do business, you have to participate in human genocide. And it's not just for employers, because I spoke to a group in Michigan. One of the things that we have said, and we're looking for plaintiffs right now to challenge this, is the individual mandate. The individual mandate, you know about that being up before the United States Supreme Court.
Well, we're out of time for today, folks. You've been listening to Mat Staver of Liberty Counsel. He was speaking at the Pro-Family Legislators Conference. Tomorrow we'll pick up right where we left off today, and then you'll have the 3-part series you can share with your friends and family. Get it all right there at our website at WallBuildersLive.com. Thank you for listening today to WallBuilders Live.
We stand undivided.